During this video, I'm going to explain the exclusive right to sell listing agreement for residential properties. So at the top, on lines 1 through 6, it gives a place to put the property's address, the dates for the agreement, as well as a legal description of the property. And then on line 8, it explains that the purchase will be either cash, conventional loan, an FHA loan, or a veteran's loan. I'm going to look at lines 12 through 18. It explains that all things that are attached to the property will be included in the sale of the property. That includes things like keys, drapes, curtains, curtain rods, blinds, screens, awnings, storm windows, bathroom mirrors, ceiling fans, and so on. You can read through those for more detail. That first box, in that first box, I need to know if there are any additional items that are not on that list that you will be leaving behind. If so, that needs to be written in there on lines like 19 and 20. And then for lines 21 and 22, if there's anything that you would like to exclude from the real estate that you would like to take with you that is not attached, that is attached, something that's attached and you'd like to take with you, you need to include that in box 22 on line 22. And then it just states that for the seller authorizes the broker to cooperate and divide the broker's fees and other brokers in an acceptable manner. So that needs to be initialed there. And on line 29, it says B, it authorizes me to put a for sale sign in your yard and to remove any other signs in your yard during the term of this agreement. And then for line 30, letter C, it explains that the property will be shown during reasonable times and you will also provide access for inspections and appraisals. And then for line 31, letter D, that you authorize us to contact any and all lien holders to obtain relevant information. On line 32, it explains that the broker agrees to perform the terms of this agreement, promote your interests as the seller in the utmost good faith, loyalty, and fidelity, including presenting all offers, counter offers, and backup offers in a timely manner. Upon the seller's execution of the contract, the broker is not obligated to continue marketing the property, but will submit to seller any offers received and update the status of the property per the multiple listing service or MLS guidelines. So the broker will market the property at the broker's expense, will disclose to the seller all adverse material facts known by the broker about the buyer and advise the seller to obtain expert advice as to material matters known by the broker, but the specifics of which are beyond the broker's expertise. So when the seller has been advised thus, no cause of action for any person shall rise against the broker pertaining to such material matters. And then on line 41C, it says that the broker agrees to disclose to any customer and seller any facts actually known by the broker related to the physical condition of the property that were omitted or that contradict the information included in the written report that was prepared. However, the broker owes no duty to conduct an independent inspection of the property for the benefit of the customer or to independently verify the accuracy or completeness of the statements made by the seller or qualified third party. So you need a signature of that page. And then on the next page, it also says the broker will account in a timely manner for all money and property received, that the broker will comply with all requirements of the Broker Relationships in Real Estate Transaction Act, which I explained in another video earlier. that letter F will not disclose confidential information about the seller unless disclosure is required. And G, disclose to the customer all adverse material facts known by the broker. So in other words, I do have to let the broker know if anything is supposed to be told to them by law. The broker is not responsible for vandalism, theft, or damage of any nature to the property. Line 58, the seller agrees to and will refer all inquiries and offers about the property to me. I will provide you some cards, some of my business cards, in case anybody comes to your door to inquire about your for sale home. In the case that happens, you give them a card and you ask them to call me, and I will be glad to show them the property. Also, you will need to furnish a key to the property and permit the broker to place a lockbox on the property during the term of this agreement or until the final settlement of sales transaction, whichever is later. You will need to provide a clear title to the property and inspection reports, including but not limited to things like septic tanks. So the seller just agrees to indemnify, defend, and hold harmless the broker for any liability, cost, or expense related to the title agency or related to the title to the property, I mean. Then on line 66, letter D, it just says that you need to leave your utilities on during the term of this agreement or until the buyer's possession of the property, whichever is later. And line 68, letter E, says that the seller will agree to thoroughly review the listing information that I prepare. So you will let me know if you see any errors or omissions, and the seller represents and warrants that the best of the seller's knowledge, the listing information is accurate. On line 70, it talks about earnest money. So earnest money is some money that's put forth by the interested buyer as good faith that they are genuinely interested in buying that property. In the case that that money is forfeited by the buyer, the seller is going to have 1/2 of that earnest money and the broker will get the other half. Compensation is 6%. That means that 3% will go to the seller's agent and 3% will go to the buyer's agent. It also says between lines 76 and 80 that the seller authorizes the deduction of the fee from the seller's proceeds at closing. And as clarification, if the sale of the property fails to close due to the seller's default or with the seller's consent, then the seller shall remain obligated to pay the broker's fees. Line 81 through 87 just explains that in the case that the property is sold within 60 days after the termination of this agreement, that an identified buyer, that means a buyer that the brokers worked with at some point or the agents worked with at some point during this agreement, still will be that the buyer will still be obligated to pay their fee if there is an identified buyer during that time. Lines 88 through 92, it's the brokerage relationship disclosure. It states that the seller acknowledges receiving that paper that I gave you, that document that I gave you and already explained in a previous video. And it says that you understand that the broker may show alternative properties not owned by you to buyers and may list competing properties for sale without breaching any duty or obligation to you. It states that the transaction broker, let me restate that on the next page, actually on lines 93 through 98. It says that the seller acknowledges that the broker may have clients who have retained the broker to represent them as a buyer in the acquisition of property. If a buyer client becomes interested in making an offer on your property, then the broker would be in a position of representing the buyer and seller both. So at that point, that broker may act as a transaction broker representing both. And at that point, there would have to be an addendum that would be negotiated between the buyer and the seller. So if you agree with that, then on line 102, please sign or initial next to the yes. For lines 103 through 110, it explains designated agency. You need to please initial next to where it says not applicable. And then on lines 120 through 135, it explains that I am your designated agent, which I already discussed with you what that means. So you need to initial yes there, and then initial again at the bottom of that page, which is on line after line 137. Now on the next page, page 4 of 5, on lines 138 through 142, it says pursuant to paragraph 8, the seller consents to the above named designated agent as a transaction broker in the event that the agent is also the designated agent for a buyer. So that would just be along, as I mentioned before, with the transaction broker addendum. So you need to initial yes that you would allow that to happen if that were necessary. Lines 143 through 148 just ask you to acknowledge whether you have a home buyer protection plan or not. So just initial yes or no. On lines 149 through 155 for item 11, it says the seller has been advised and understands that the law requires disclosure of any known material defects in the property to prospective buyers, and that failure to do so may result in civil liability for damages. So that just is letting you know that it's important to disclose the information about the property that you understand. Then on line 12, I'm sorry, line 156, item 12, it's a notice to sellers who are foreign persons. You only need to initial that either you are not a non-resident alien, or that you, if you are a non-resident alien, then initial on that second line, and I will share with you the necessary documentation. Lines 163 through 169, item 13, just explains that I'm going to be submitting the information about your property on the MLS so that it will be made public to anybody who wants to learn about your property and is interested in buying it. And it also means that that information, including the sales price, is going to be available on the market. So on lines 170 through 176, it discusses distribution of information. It states that the seller authorizes the broker to disseminate data about the property and other information relating to the property, including works depicting the property, such as virtual tours, images, etc. That'll go on the MLS and other websites. Line 177, you acknowledge the distribution of that information by just initialing yes. And then on line 179, if you desire to restrict the marketing, then you will do that. You will initial there only if it's applicable. Then you need to initial the bottom of the page. And then on the next page, which is page 5 of 5, just initial those if you're not going to authorize B, C, or D on lines 181 through 84. Line 87, item 15 just states that the property will be offered, shown, and made available for inspection and sale to all persons without regard to race, color, religion, sex, disability, age, familial status or national origin. Line 16 or line 189 through 196, item 16, just fill in if there's any other information. You might consult with me first before putting anything there. And on line 197 through 200, you're just giving permission to use electronic signatures. On line 201 and 202, item 18 explains that there is in this agreement, it's to benefit the seller and the broker. It's fully binding upon your respective heirs, executors, personal representatives, administrators, successors, and assigns. On line 203 through 204, item 19, this agreement constitutes the entire written agreement between the parties and supersedes any previously executed contracts and representations, verbal or written. And then it says the seller represents and warrants to the broker that all parties with any ownership interest in the property are parties to this agreement. No other listing agreement to sell the property is in effect, and the seller is able to convey merchantable title to the property at closing. So please acknowledge your receipt of the agreement and sign it. This is a legally binding agreement. If not understood, please get competent advice. The broker recommends to the seller to retain independent legal counsel to answer any legal questions involved in any real estate transaction. Thank you. And if you have any questions, let me know. Monica Gross, 316-518-5391. Please call or text.